30th August 17, Pakistan responded to the communication of 19 June by which the request for mutual legal assistance had been declined. Being faced with no mutual legal assistance resolution imposed overriding obligations on member states to afford one another the greatest measures of assistance in connection with criminal investigations. India continued to request for consular access by its letters of 20th September and 9th October. Pakistan's letter, however, considers India's regrettable stance, quote unquote, in the International Court of Justice, which ignored what they say repeated attempts by the government of Pakistan to provide an opportunity for the government of India to give evidence, either exculpatory or inculpatory, of Commander Jadhav. They failed to notice that Pakistan's misadventure in trying to publicly air the confession and raise the issue relating to his passport did not succeed in the court. The Pakistan letter stated that the request took the form that is internationally recognized. I will show you why this is plainly wrong in due course. The letter stated that some of the evidence underpinning the allegation has been made available to India. To be clear, Jadhav is unlikely to have been convicted and awarded the death sentence merely because he had, as alleged by Pakistan, a passport in a different name which would hide his identity. He was presumably found guilty of serious offenses which carried the death penalty as a punishment. Pakistan has steadfastly refused to disclose which specific events, which specific offenses related to which specific events, in relation to which Jadhav now stands convicted. The letter then audaciously states that it was, quote, incumbent upon the government of India to explain, unquote, the passport issue. And it closed by saying, open quote, to facilitate the Republic of India's compliance, the request is provided again, unquote. On 26 October 2017, Pakistan wrote to India reiterating its stand, which it had taken in the communication of 30th August, but added, and I quote, without prejudice to the proceedings so far, government of Pakistan is prepared to consider any request for extradition that the government of India may make in the event that Commander Jadhav is considered to be a criminal under the law of India, unquote. India responded to Pakistan's offer for extradition. It pointed out by its communication of 11th December that Pakistan's communications of 30th August 17 and 26th October 2017 were again yet attempted propaganda, and India was not possessed of any material which would give them to suspect that Jadhav had committed any crime for which he could be tried in India. Pakistan offered to allow Jadhav's family to visit him. The terms were agreed and the meeting was held on 25th December 2017. India was dismayed at the manner in which the meeting was conducted and wrote a letter on 27 December marking its protest at the violation in the letter and spirit of the understanding which had been arrived at in relation to the meeting. Pakistan responded to India's communication by its note verbal of 19 January 2018. On the same date, Pakistan responded to India's communication of 27 December, contesting some of the allegations made by India in relation to the meeting. India responded on 11th April 2018 to Pakistan's communication of 19 January 2018, pointing out that the passport which had allegedly recovered from Jadhav was characterized as being patently false, and to investigate any such allegations, India would have to inquire into the circumstances in which the passport was recovered. Having finished with the factual narrative, I now move, sir, to the first issue of relevance, the construction of the Vienna Convention. Article 36 of the Vienna Convention is in language that admits of no ambiguity. Paragraph 1b of Article 36 requires the competent authorities of the receiving state, if requested by the national of a sending state, to inform the consular post of the sending state that a national of that state is arrested or committed to prison or to custody pending trial or is detained in any other manner. In addition to this right conferred upon the arrested national, paragraph 1C confers upon the sending state the right to have its consular officers visit a national of the sending state who is in prison, custody, or detention, to converse and correspond with him and to arrange for his legal representation. Paragraph 2 of the treaty as places, as it were, above national laws, for it mandates that while the rights to consular access shall be recognized in conformity with the laws and regulations of the receiving state, this is subject to the proviso that the laws and regulations must enable full effect to be given to the purposes for which the rights accorded under the article are intended. Article 31 of the Vienna Convention of the Law on Treaties, 1969, which I shall be referring to as the VCLT, requires that the treaty be interpreted in good faith in accordance with the ordinary meaning to be given to the terms of the treaty in the context and in the light of its object and purpose. The expression context is defined in Article 31, paragraph 2. In relation to the Vienna Convention, it's India's case that it is the text that would govern its construction. The first approach based on literal interpretation of the language is the objective approach, as against a subjective approach which searches for the elusive intent of the parties. The teleological approach is a wider perspective and emphasizes the object and purpose of the treaty as a backcloth against which the treaty should be construed. These conflicting principles, the objective approach, the subjective approach, and the object and purpose approach have been codified in Articles 31 to 33 of the VCLT. I need labor this no more because the construction of Article 36 of the Vienna Convention is no longer res integra. In the Legrand case, this court construed Article 36 and held, and I quote, Article 36, paragraph 1b spells out the obligations of the receiving state has towards the detained person and the sending state. The clarity of these provisions, viewed in their context, admits of no doubt. It follows, as has been held on a number of occasions, that the court must apply these as they stand. In the 2004 Avena judgment, this court held that the court would recall that it has in any event essential to have in mind the nature of the Vienna Convention. It lays down certain standards to be observed by all state parties with a view to the unimpeded conduct of consular relations, which, as the court observed in 1979, is so important in present-day international law in promoting development of friendly relations amongst nations. And I have taken the liberty of emphasizing this, ensuring protection and assistance for aliens resident in the territories of other states. Recognizing the duality of the protection afforded by Article 36, this court in para 40 of the Avena judgment said that, quote, it would further observe that the violations of the rights of the individuals under Article 36 may entail a violation of the rights of the sending state, and that the violations of the rights of the latter may entail a violation of the rights of the individual. Eric Bjorge, in his book, The Evolutionary Interpretation of Treaties, cites Berman's Community Law and International Law, which argues that VCLT and the rules, when they were adopted in 1969, and I quote,